In this video, I'll explain the forms used in a real estate transaction using our form checklist. And these are the forms we require when a file is submitted. And I drafted this checklist of forms with the intention of keeping it minimal, but also meeting all the statutory or legal requirements, and then adding any forms that I think greatly mitigate our legal risk. And that's so that in cases of audits, or if our E&O company or a legal claim examine our paperwork or it gets brought into question, they'll see we're compliant and that we did everything we could to reduce our risk and liability by having all the proper forms in place. So let me jump right into it. I'll explain the purpose of the forms that we have in here, why we have it, and I'll try to go through it swiftly so it's not too boring. And we start by, so these are all grouped up. We start with opening our starting documents, listing agreement, obviously, when the listing agent, if you're the buyer's agent, you don't need to submit it, of course. Buyer's pre-approval or pre-qualification from a lender, optional but not necessary, helpful to have. The RPA, residential purchase agreement, it comes in a bundle, which includes some of the forms on here. But sometimes agents take the RPA itself out of the bundle. But we have the purchase agreement mentioned here, any counteroffers used in the transaction, any addendums that were used to amend the terms in the purchase agreement, the MLS sheet, and we have the seller sign the MLS sheet. The reason is that sometimes agents enter the wrong information by accident. The seller doesn't know and can't correct the agent. Now the agent's misrepresenting features about the property, and that causes a legal risk. So by having the seller view and certify what's the information on the listing sheet, that further reduces risk of misrepresenting the property. The EMD receipt from escrow. This timestamps when escrow received the earnest money deposit and also the amount. It's good to have on your record. FHA and VA mandatory clause. This is a form. There's a CAR form, but there's also a lender form. It's required by lenders on any transaction in which the buyer is getting an FHA or VA loan. So that's why we write when applicable. Wire fraud advisory, not legally required, but a smart form to have, especially given the prevalence of wire fraud in recent years. This is actually part of the RPA bundle, the purchase agreement bundle. So as long as you keep that bundle intact, it'll save you the hassle of having to go back and double up on these forms and have to go back later and add them. That includes these forms in this group, disclosures and reports. The agency disclosure, that's already in the bundle. If you're the listing agent, it's in the residential listing agreement bundle. If you're the buyer's agent, it's in the purchase agreement bundle. So it's already there. But again, if you're in a situation where the RPA or RLA has been extracted from the bundle, make sure you have this form. These are legally required by the state of California. Lead disclosure, legally required if built prior to 1978. The Natural Hazard Disclosure Report, this is a legally required disclosure. And we have the report itself, which is usually like 20 pages or something like that, and or longer if there's an environmental supplement. And then we have the NHD signature page. In this report, there's one page that certifies the information or actually acknowledges receipt of the information, but there's a signature page in this report, and that's what this is. So we need that, both of those. These are legal requirements. Real estate transfer disclosure statement, also known as the TDS, required by state law. There are rare exceptions, like if the home's held in a trust and the trustee has not resided in the home, I think in the last 5 years, then there's an exemption. But generally speaking, this is required, and there's really no harm in always doing it whenever possible. It's always good to over-disclose than under-disclose. Yes, believe it or not, this was done with a minimal approach, and this still is how long this list is. So just keeping in mind, and it can get far more absurd if someone wants to be pedantic. All right, residential earthquake hazard report signature page. This, if you do a web search, you will find blank copies of this form. This is not a CAR form. We only require it on homes built prior to 1960. The FERPTA form is a certification of non-foreign or foreign status. The reason is that if the seller is a foreign person or entity, and then they're required to withhold some of the proceeds for tax purposes. If they don't, then the buyer will be held responsible by the IRS. I've gone through this nightmare personally. We had a transaction where the seller was I don't think they were an entity. I think it was actually a person. It's a foreign person. They did not do withholding. They had all the proceeds go to them. There was no withholding. The IRS went after the buyer. And if a buyer is getting a tax bill for a seller that didn't pay, the buyer is likely going to sue everyone or be extremely angry at the very least. So this form is a very, very simple remedy to avoid that nightmare scenario. I can tell you firsthand, it's a total disaster to go through. Seller's questionnaire, not required by law, but very smart to have in your file. Water conserving plumbing fixtures and carbon monoxide. This is a combo form, 2 functions, 1 form, required by law. Statewide buyer and seller advisory, not required by law. Again, smart to have in your file. I think it's 10 pages long, or at least it used to be. Everything gets longer and adds up. Soon this will be a book of pages of forms in the future. But this particular form, SBSA, it informs both parties what they should be aware of and look out for. If your company has any affiliates, this form must be done to be in compliance with the federal law, RESPA, and I believe there's a state version of that as well. But either way, there must be an affiliated business disclosure statement that we require and many other brokerages require. This is a newer form down here. If there's a high or very high fire hazard risk, which can easily be found on the NHD, the Natural Hazard Disclosure, or through a web search. There's all sorts of maps now you can find for California where you can put in an address and see if it's in a high fire hazard zone. Then this form is then required. Fire hardening and defensible space advisory. HOA docs. We used to not require this because technically by law, this isn't a requirement for the brokerage to hold on to. The buyer should acknowledge HOA docs if the property's in an HOA. That's part of the process, and that's typically done through escrow, but we require copies of it all because for liability purposes. I mean, we've done thousands of transactions, so if there's a way something can go wrong, I've seen it happen. So now we require it just so we're privy to the same information that could be cause for a dispute down the road. Inspection report clearances. We ask for a contingency removal, copy of that if it was used in the transaction. We ask for a property inspection report, and if no inspection is done, a waiver, buyer inspection waiver, form BIW. If there's a request for repairs, we want to see that paperwork in there. Again, inspection waivers if there's no property or termite inspection. If there is a termite inspection, we want a copy of it, and if there is termite work done, we want a copy of the completion. Title and escrow. Escrow instructions, just a copy of what escrow created. Unsigned is fine. The title report on the property, and then the home warranty plan confirmation if it was used, if it was ordered. Some of these things, I mean, the broker is not required by law to have a copy of something like this down here, the home warranty, for example. And I would argue even escrow instructions. But you have to understand that brokers get dragged into everything that goes wrong. So if we get a letter down the road that the buyer is going after the seller because there was something in the HOA that they didn't know about, or the home warranty was ordered wrong, or whatever it is, we want to have a copy in our records so that we can look at it and furnish it to our E&O company, our insurance company, or our attorney, or whoever we're using, even me answering a phone call or a letter, and say, no, we reviewed it, and the buyer signed off, so we're no part of this. Everything was done properly. Anyway, the point is you want to have this information as a reference because you'll get dragged into it if something goes wrong. Closing documents. Closing statement, of course, from escrow. Used to be called a HUD. The old timers still call it a HUD. It's not. I shouldn't say old timer, not old timer like age. Old timer is a veteran of the industry, because anyone that's been around for even just a few years in the industry calls it a HUD, but it's not. It's a closing statement now. HUD's obsolete. Verification of property condition, VP, not required by law, but smart to have, that the buyer's signing off on that the condition hasn't substantially changed since they first walked through. And copy commission check. I mean, these are broker and local disclosures. These are just broker specific. Local disclosures. I mean, if you're ideally, you'd know if there are any local disclosures depending on what area you're conducting business. That's it. That's our checklist. This is tried and tested through thousands of transactions at this point. If you have any questions, please comment below and I'll be happy to answer. Thank you for watching. I hope you enjoyed it.